Hello and welcome to BYJU'S IAS. Let's get started and look into our daily quiz. Let's look into the first question. Consider the following statement with respect to 0R. It is not mentioned in the rules of procedure. It is an informal device available to the members of the parliament to raise matters without any prior notice. The idea was imported from Japan. Which of the above statements are correct? The answer to this is 1 and 2 only. Why have we taken this practice question? Because this article on the Hindu makes a mention of the 0R in the Lok Sabha. Let us try and understand what are these options. When it comes to the parliamentary democracy in India, we have the legislature, we have the executive, we also have the judiciary. These are the three organs of the state. Let's forget the judiciary. What we have is the legislature and the executive. The executive keeps a check on the legislature keeps a check on the executive, and what we have is a relationship where each has a check and balances on one another. As part of the question R, we have the legislature which keeps a check on the executive, where the legislature can ask questions to the executive and the ministers will have to answer all these questions. That is what is called as question R, where questions will be asked by the legislature, the members of the parliament, to the executive, that is to the ministers in the government. Now, what follows the question R is what is called as 0R. It is primarily called as 0R because of two important reasons. When it comes to the question R, it generally happens between 11 to 12. Because the 0R happens at 12 p.m., it is called as 0R. That is one of the reasons. The other reason is when you look into the dictionary meaning of 0R, what does it say? It speaks about the military action. It speaks about a time set for the beginning of an attack according to military parlance. If you have to bring that into the parliamentary parlance, what it means is real action begins in the house at that hour, which is at 12 o'clock. So basically, you have the members of the parliament who would be able to discuss some of the issues which are of importance, which are of national importance, and those where the members of the parliament feel is important from their constituency. They can discuss all of this without any prior notice. So the second statement is right, as it is an informal device where prior notice need not be given by the members of the parliament. Yes, it is not mentioned in the rules of the procedure, while the question R is mentioned, but this is not mentioned under the rules of the procedure. The idea is not imported from Japan, but instead it is an Indian innovation in the field of parliamentary procedures and has been in existence since the year 1962. Now let's look into the next practice question. With respect to state legislative council, which of the following statements are incorrect? Indian citizen who is at least 25 years of age can become the member of legislative council. The chairman of council is nominated by the governor. Currently, 7 states in India have a legislative council. Which of the statements are incorrect? Since it is asking for the incorrect statement, the answer to this is 1, 2 and 3. Why have we taken this practice question? Because this article on the Hindu makes a mention of the legislative council. Let us try and understand what are these options. When it comes to the first option, Indian citizen who is at least 25 years of age. This happens to be a wrong statement. It is 30 years of age and such a person would be able to contest elections. So the first statement is wrong. When we look into the second statement, the chairman of the council is nominated by the governor. This is once again a wrong statement. Why? Because the chairman of the council is elected from amongst its members. So you have the members who are part of the legislative council. They elect the chairman of the council. So the second statement is wrong. When we look into the third statement, as of now, we have 6 states in India which have a legislative council. Which are these states that have the legislative council? Please put it on the comment section. Now let's look into the next practice question. Which of the following are the point sources of water pollution? Oil refineries, paper and pulp mills, agriculture runoff, sewage treatment plants. Which of the following are the point sources of water pollution? The answer to this is 1, 2 and 4 only. Why have we taken this practice question? Because this article here makes a mention of non-point sources of pollution. What is the difference between point source of pollution and non-point source of pollution? As the name denotes, it is point source of pollution where the pollution is from one single area, where pollution occurs from one single identifiable source. Let's say for example, we have any of these sources. For example, the oil refineries, you know for the fact that pollution is coming from the oil refineries. You know from the fact that paper and pulp mills can release some effluents, and this is where it is acting as a single point of source. Then you have the sewage treatment plants, it is acting as a single point source. So you would be able to establish that pollution is coming from this particular point, which is why it is called as point source of water pollution. However, if we speak about agriculture runoff, what is agriculture runoff? It can be because of the fertilizers, it can be because of the erosion. We do not know. It is one point of source. It has a wider area. Pollution occurs from different sources. It has a wider area. That is what is called as non-point sources of water pollution. So in the point source, you would be able to directly understand that pollution is from a single source, from a point source, from a particular area. But when it comes to non-point sources of pollution, it means that you would not be able to figure out there is a larger picture, there is a wider area of pollution, which is called as the non-point sources of pollution. This can be because of erosion, transportation, sedimentation of rocks, soil, agriculture runoff, open defecation, runoff from solid waste dumping sites, so on and so forth. So basically, when we speak about the point sources, if we have a treatment plan in that particular area, we would be able to reduce the impact of the pollution. But a treatment plan may not be effective when it comes to the non-point sources. Further, the article makes a mention of heavy metals. What are these heavy metals? They are defined as those elements having an atomic number greater than 20 and atomic density above 5 gram cubic meter and must exhibit the properties of metal. Some of the examples include mercury, cadmium, arsenic, chromium, thallium and lead. These are some of the examples of the heavy metals, and if they are present in that particular river, this can also cause increasing pollution and may also have health implications on the people consuming this water. Now let's look into the next practice question. With respect to Payments Bank, which of the following statements are correct? Payments Bank can issue debit cards and not credit cards. They are given a provision to lend small businesses. They are not allowed to accept time deposits or fixed deposits. Which of the statements are correct? The answer to this is 1 and 3 only. Why have we taken this practice question? Because this article here makes a mention of Payments Bank. Let us try and understand what are these options. When it comes to the payment banks, what are these? These were established on the basis of Nachiket More Committee, where the Nachiket More Committee recommended for the establishment of the payments bank. Why? That is because India does not have many individuals, persons who do not have a banking account. To ensure that these people become part of the financial inclusion scheme, a suggestion was made for the establishment of payments bank. So what is this payments bank? This is like any other bank, but they operate on a smaller scale where they would be able to accept the money, but they would not be able to give loans to people. Generally, when it comes to the commercial banking, what would happen? You would be able to make deposits as well. These deposits can be in the form of current account, savings account, and it can be fixed deposits as well. But when it comes to the payment bank, they are not allowed to accept time deposits or fixed deposits, but you would be able to have savings account or the current account. When it comes to these payment banks, they can also give you debit cards, but they cannot issue credit cards. And when it comes to the payment banks, they cannot lend even to the small businesses as well, which is why the second option is wrong and only 1 and 3 are right. So it is B for this particular question. Now let's look into the next practice question. Which one of the following objectives is not embodied in the preamble to the Constitution of India? We have liberty of thought, economic liberty, liberty of expression, liberty of belief. The answer to this is economic liberty. When it comes to the preamble of the Indian Constitution, it provides for the liberty of thought, expression, belief, faith and worship, and does not make a mention of economic liberty. And this happens to be a previous year question from the year 2017. Now let's look into the fact of the day. The fact of the day for today's discussion is Model Tenancy Act. Why is it called as the Model Tenancy Act? When you go back and look into the statistics, according to the Ministry of Housing and Urban Affairs, there are as many as 1.1 crore houses that are currently laying vacant. Why? That is because of the issues between the tenants as well as the landlords. In order to overcome this particular issue, the central government has come up with the Model Tenancy Act. Why is it called as the Model Tenancy Act? That is because when it comes to land in India, land comes under the state list. We have the 7th schedule, we have the union list, state list and the concurrent list. Land happens to be one of the subject matters which is present in the state list. So what is the central government saying? That there are issues between the tenants as well as the landlords, which is why we have large number of rented house which are currently laying vacant. So we have to ensure that these issues have to be addressed. Since land is a state subject, we are only going to propose a model, will give you an idea, so it is left to the state governments to implement it or not. So basically you have the central government giving suggestion to the state government that this is a voluntary scheme, it is not binding on the state governments, you would be able to adapt it, make use of this existing law as proposed by the central government to bring in changes in your own law. So this happens to a voluntary scheme where the central government says that you can either adapt it or bring changes to your own existing laws. What are some of the provisions as per the Model Tenancy Act? As of now, there is a trust deficit between the tenants and the landlords. So clearly delineating their obligations is one of the primary objective of the Model Tenancy Act. So who is a tenant? He is that particular person who occupies the property of another person for a temporary period of time by signing a lease or a rental agreement. So the Model Tenancy Act requires that the state government establish what is called as the rent authority. So who is this rent authority, or what is the function of this rent authority? Basically, it will be this rent authority who would be responsible for registering all rent agreements. Such an authority would maintain all the records of the rent agreements under it and will also have a website for tracking of such data. So any issues and disputes, the rent authority will have all the data. So in the near future, there will be establishment of the tribunal as well as the rent court, so they can look into this particular website and understand where the problem lies. When it comes to the Model Tenancy Act, it also speaks about the security deposit as well. What is a security deposit? It is that money which is also paid as the advance. So when it comes to the normal houses, residential houses, it means that a person, the tenant who is entering into an agreement with the landlord or the owner, will have to pay 2 months rent as the advance or the security deposit. But when it comes to commercial property, that tenant will have to pay 6 month rent as the advance. This tenant who is entered into that temporary house cannot sublet a part or the whole part to someone else. And at the same time, in case of any issue between the landlord as well as the tenant, the landowner cannot cut power and the water supply. And at the same time, if there are any issues, it is the responsibility of the landlord to also ensure that all the structural repairs in that particular premises is undertaken by the landlord. What are the advantages of the Model Tenancy Act? It will encourage the growth of the rental housing in India. The disputes that have been in existence between the landlords as well as these tenants will ultimately be sorted as well. However, since this act is not binding on the states, whether they will implement or not is the question. So the Model Tenancy Act aims to balance and protect the rights of both the landlord as well as the tenants. It is this that we have to understand in reference to the Model Tenancy Act. So this is it for today. Thank you for watching. All the best.